Good morning. This is the House Commerce and Economic Development Committee. Today is Wednesday, January 28th. It's 9:03 in the morning. We are here to talk about H205, an act relating to agreements to not compete. Jessa Barnard is here with us this morning. So good morning.
Yeah, thank you so much for having me. Jessa Barnard. I am the executive director of the Vermont Medical Society. It's my first time here this year, so thank you for welcoming us. We represent individual physicians, physician assistants, and medical students. So we are try to be the voice of individual clinicians rather than any employer type or facility. Our members work at hospitals, independent practices, federally qualified health centers, sort of across the healthcare landscape. And we were part of the work group that met over the fall to talk about agreements not to compete. And we support the new direction that the draft is taking in H205. I will talk a little bit about why this is an important issue in healthcare, because I'm not sure you've sort of necessarily heard exactly the healthcare perspective, but we do support restricting the use of non-competes to the maximum extent possible. Also appreciate addressing non-solicitation and stay or pay provisions. I do have some sort of requests for either additions or clarifications in the language, but again, in general, we do support the direction that this draft is taking. We think that agreements not to compete are a particularly important issue in healthcare, not only for sort of from the workforce perspective to allow individual clinicians to be able to make the decision of where they best want to work, where they want to serve patients, to potentially be able to move from hospitals to independent practice or vice versa and serve Vermonters. But really also from the patient perspective of making sure patients have choice, have options, have access to their healthcare providers. It's been an issue that's been taken up or looked at the federal level. The Federal Trade Commission actually as recently as this fall issued warnings to healthcare employers and staffing firms to take a close look at employment agreements. And they recognized the harmful effects that non-competes can have in the healthcare market in terms of restricting patient choice of care, especially in rural areas where access to services is already maybe more limited, like here in Vermont. The American Medical Association disfavors covenants between employers and physician employees and state that they can restrict competition, disrupt continuity of care, and limit access to care. So again, sort of in summary, we do think non-competes can restrict patient access, disrupt care continuity, especially if you think about more hard to find specialty services that may only have one or two providers giving that specialty care in a certain area, reduce clinician choice and increase health disparities. So we actually support in an outright, and I shared this with the group meeting over the fall, an outright prohibition on non-compete specific to healthcare, or at least in I can really only speak to healthcare because that's my, where I work. That is not uncommon. Many states actually have healthcare specific provisions around non-competes, either banning them or significantly restricting them. The language varies somewhat between how the states have approached it, but we do think that a ban for healthcare extended to all types of healthcare professionals makes sense. We see, the draft 1.2 in H205 takes a little more narrow approach with only an exception as we read it for those individuals who are executive level employees making over $100,000. We do think that language around executive employees is at least a good starting point. We think that will generally extend the ban to most healthcare providers. We would welcome or encourage, if possible, a little more definition around what that means to be an executive level employee, especially in the healthcare setting, just so there's clarity around who's really in or not in that kind of a restriction. But we do appreciate that approach. I do want to mention that at this point that there is also a bill in the House Healthcare Committee under consideration right now, a much broader bill that really is intended to more get at the role of private equity in healthcare, but that does contain a ban on non-competes in healthcare for healthcare workers. And so that will also need to be sort of reconciled how this, if both are moving, how they work together or do they work together clearly. So again, while an outright ban in healthcare specifically is our first preference, we do think the executive level employee approach at least is an important, very important starting point and would support moving forward with that. We do think clarity around non-solicitation is very important. We think that overly restrictive non-solicitation agreements can prevent healthcare professionals from communicating with patients that limits continuity of care. In fact, I've had this own personal experience when my provider left a local practice and I wanted to know, well, where did they go? I was told by the receptionist, oh, I can't tell you, they've left. Whether that's an accurate interpretation of a non-solicitation agreement, I don't know, but at least that's the way it's being communicated to patients. So you can't even if you want to follow that provider somewhere else, you may not be able to. So we strongly support the language in H205 that says that healthcare providers can provide notice of their change of employment, even if you're not going as far as sort of a ban on non-solicitation agreements, which we would also support. We would support some additional clarifying language that gives a little more definition again around what that means to provide notice of your change in employment, just so there's not kind of confusion about what can be said or cannot be said. With my testimony, gave some suggestions taken from Colorado, which delineate a little more clearly. For example, a healthcare provider can state they are continuing to practice medicine, their new contact information, and the patient's right to choose a healthcare provider. So again, it just gives a little more definition around what contents can be communicated to a patient when you change employment. We think that could be helpful clarity. We do support the continued use of pay or stay provisions. They are actually quite an important tool in healthcare, in particular for training employees and retaining employees. So, for example, helping train a nurse from one level to another level of nursing, and then saying, if for every year you continue to work, we will pay this year of tuition, that kind of thing. I know you walked through what those provisions might look like. We are comfortable with parameters like in 205 around when they are or are not enforceable. We do think it might be important to clarify. I didn't see this in the bill, though it's possible I missed it, whether that's just prospective versus retroactive, because there could be employees kind of currently in the middle of one of those provisions, and it could be hard to modify that kind of while that's in effect. So again, we would sort of appreciate clarity that these new guardrails around what they can contain would be for new agreements entered after the passage of the bill. One element that I did not see addressed in the new language that we've also been paying attention to is trying to address the component of contracts entered or drafted by an out-of-state employer that impacts somebody working in Vermont. So the example we hear most often in healthcare is a staffing agency, like a nurse staffing agency that may be located out of state but they have placed the nurse in a Vermont healthcare location, and that nurse may want to stay. In fact, and ideally, that's what we would love, is more nurses and physicians and others coming to Vermont wanting to continue after that contract ends. And yet some of those staffing agencies do use non-competes, and so that sort of prohibiting that nurse from doing so. And so this was an issue, actually, we shared some language that New Mexico has adopted to try to address the fact that healthcare employment agreements cannot be subject, if the person is working in Vermont, can't be subject to the laws of another state. They have to be subject to the laws of Vermont, so that if Vermont says we don't allow covenants not to compete, that contract controlling that employee's work in Vermont has to be subject to Vermont's laws, rather than be a contract that was drafted and subject to the laws of wherever that staffing agency is based, so that we can try to make sure that nurse or other healthcare worker wouldn't have a covenant preventing them from continuing to work in Vermont after the fact. That makes sense. So just the language, again, is specific to healthcare that I included, though I think it could be adapted to be broader if, since this bill obviously is not just limited to the healthcare context. So again, thank you for taking up this issue. We think it's really important. Our members very much support moving in the direction of a much narrower use of covenants not to compete, and I'm happy to stay engaged in this work and bring the perspective of healthcare employees to the work. Happy to answer any questions.
Any questions?
Thank you very much. Thank you for your time this morning.
Yes, I know that Our healthcare committee is looking at,
Mentioned it.
she did, okay.
Yeah, so their bill is I also have some suggestions for that bill because it's really basically one sentence in the bill saying there cannot be non-compete agreements in healthcare. And so I think that needs a little more definition. I don't know. I know that bill will be getting some redrafts. It is a very small component of that bill. That bill is really looking at more broadly the role of private equity in healthcare. So I do not have a crystal ball to know what direction that committee is going with the bill in general or that section. But at this point, there is some lack of harmony between the two sets of language. So I think that will need to be cleared up in one place or another, sort of are both moving one or the other, and what direction are they going? Because right now there would be some inconsistencies between the two.
The conversation, I guess, should be in one place or the other, but not both. And if they're in both, they should be consistent.
Agreed. Thank you. Yeah, thanks for looking at that issue. Thank you very much. Thanks for your time this morning.
Thank you. Chris?
Morning, Mr. Chair, committee members. For the record, Chris Delia, President of the Vermont Bankers Association. Thank you for the opportunity to testify on this new draft of H205. If I need to switch hats from running the summer study committee to the VBA, I'm happy to do that, but I'm going to start with the VBA hat on and just offer comments on this draft. Let me begin by saying thank you. This is a big step in a positive direction from our perspective, this new draft, and we greatly appreciate you taking into consideration the work of the Summer Study Committee and Representative Olson and Representative Duke and their interest in this. I had the opportunity to go through the bill last night line by line, so I'm going to offer some comments and seek perhaps some clarifying answers, if you will, or just put some issues on the table for clarification at some point. So as I went through the bill, starting on page 1 with the legislative intent, no issues there. With, again, on page 1, the definition section, agreement not to compete, no issues. On 1B, which is agreement not to compete, no issues there. On page 2, line 12, this is the executive employee. I guess similar to you, Mr. Chairman, yesterday, highest level of employee to me just doesn't make sense because that does seem to limit it to the top individuals. So I think whether it's senior executive officers or however you decide to define that, I think there's lower categories below that CEO, but still you can call him executive employee. Page 2, line 15 on no solicitation, no issues. But on page 2, line 21, I do have a few comments, and that's parentheses B, line 21, and that flows over to the top of page 3. So I understand what you're trying to accomplish and absolutely have no objection to a consumer wanting to go with their provider, lawyer, healthcare, fiduciary, whoever it may be. But I'm concerned about the grayness of this language. And I think we need to understand what, if anything, already exists for those entities that you call out. Let me say 2 entities. I'll leave healthcare out because Jessica did a great job on that. In talking with a friend in the legal community, he's under the impression there's already an obligation on the part of the lawyer to communicate to their client. I'm trying to find out if that's true for fiduciary as well. So calling these 3 out, you may not need this language. However, if you decide to put the language in, I don't think there's enough guardrails because each one of us is going to come up with a different type of letter and language in the letter that we're going to use to our customers. So whether it's something that you look at as Jessa just explained to you, or as we've done in statutes for many, many decades, a short form with a clear letter, paragraph that says, I'm doing this, this, and this, period, end of discussion. What I'm concerned with is we'll all come up with something different, and the employer can look at that and say, I think you're on that fine line of solicitation. And I think we might open up the door for some legal conflicts, if you will. So I think the more prescribed you can be in what goes in that letter, I think the better off we are as far as providing that opportunity. On page 3, line 4, severance agreements. This is something that I had mentioned to the committee last year, and I'm appreciative of the way this paragraph is written. What I want to convey to the committee and still working on, and I will certainly work with Ledge Council on this if necessary, is there are defined compensation agreements also considered severance agreements. You're going to terminate employment. I get to retirement age. I terminate employment. I've got a defined or what's called in some cases a non-qualified deferred compensation plan, which is recognized under IRS. Is that a severance agreement? And I just want to make sure that we have some clarity that severance is expansive enough to include those defined compensation agreements, because that person is getting compensation as they go out the door. If they wish to jeopardize that compensation by going to work for somebody else, they know they're going to jeopardize that. And I've heard of stories where the future employer pays the employee for the losses that they experienced with that defined comp. I just want to make sure that we're covering the bases with that severance piece.
Is non-qualified plans, when someone separates, I'm just wondering under UI, if they were claiming unemployment, would that, I know with severance, you lose your ability to collect until your severance is, package is done. That'd be the same as.
The experiences that I'm aware of are at the time somebody decides to retire, not when somebody is let go from employment. So I don't know the answer to your question. Page 4, wage threshold. I think you guys are going to have the conversation and make the policy decision on wage threshold. I would just offer a couple of things. Ledge Council provided to you a comment, and we provided in our report, wage thresholds are all over the map. And what is the right wage threshold? Is it 100,000? I would say I think that's too high. Is 100,000? I think others will say it's too low. And we leave it to you to deal with the policy issue. I will say a straight figure in statute is stagnant. It doesn't allow for growth, whatever it may be. It doesn't fluctuate over time, and I would not recommend doing that. I would recommend some type of an approach that allows for growth over time, whether it's some percentage of poverty level or whatever it may be. The second issue, and Representative Olson and I have been talking about it, is wage is one thing. It's also the function of the person in the job. I think of startups out there where you don't have the money to pay that high wage, but the person is involved with trade secrets, is involved with critical business information. I would ask the committee to also consider that and do it in an or approach, not an and approach. So that you may have that high level exec at 100,000 or whatever the number is. No issue. But you know as well as anybody with the tech community we have in Vermont, startup, I'm not making 50,000, but I've got all of the secrets that that company is involved with, I'm working on. And how is that taken into consideration in this discussion? Because I think you want to protect that information for that company. So wage isn't the only answer, in our opinion. The next issue is on page 4, lines 13 and 14. Again, I think this is an issue the working group brought to your attention. It's the new hire is easy to deal with. Agreements provided at the hiring process, the time limits all apply, et cetera. But you do have situations where I am the employer, Representative Olson is the employee. I want to move Representative Olson to a position that is dealing with that sensitive trade secret business information that you all have nicely dealt with in the bill. I want to give Representative Olson a non-compete agreement, go through the whole process of disclosure, et cetera. This bill does not speak to that. This bill only speaks to new employee. And we would ask you to look at both existing and new employee. Same approach, no problems, but just expand that. And then the final thing that I looked at was the state of pay provisions, which I appreciate the approach that you've taken in there. But again, I want to flag for you what I think is something that could be problematic. And that is on page 6, line 9, parentheses B. And it's really the word retaliation. I don't know how that's defined, if at all. And I think all of us could probably come up with different thoughts on what retaliation means or doesn't mean. For example, and I'm not disagreeing with the retaliation, I'm just trying to figure out what the scope is. If I have Representative Olson as an employee, great guy to pick on this morning, thank you, as an employee, and I want to move Representative Olson to a new position, but there's going to be training that's required in order for him to do that work. If he does not want to go through that for some reason or whatever, and he is not eligible to move into that new position, am I in any way retaliating against him because I'm not giving him that new job? He's not qualified for that new job without the training. I'm trying to eliminate any, again, potential gotchas where we're all going to come up with a different view of what retaliation means. And somebody who knowingly retaliates absolutely should be addressed, but where's that gray area that people might get trapped in? Other than that, again, I thank you very much for the work that you did on the bill. From others this morning. And again, I'll also just thank all of the folks who worked on it this fall to help you make the changes and review that you're doing. Thank you.
Good morning. David Mickenberg here on behalf of Working Vermont, which is, just as a reminder, the largest coalition of public and private sector labor unions in the state of Vermont. And we advocate on behalf of working issues generally. So, and I want to say we participated in the working group over the summer and fall, and just a big shout out to Chris Delia for organizing a very animated and an energetic group, and he did an amazing job. And I really appreciate all the work that he did with us on this issue. So as you know, on the most basic levels, we just see non-competes as a restraint on employees' opportunity to seek other employment. And we support a lot of what's in this draft and appreciate the good work that's gone into it. It's estimated, just for a little context, that some 30 million Americans are subject to non-competes, which is 18% of the workforce. And oftentimes, while these agreements are for higher paid employees, 30% of the workers that are subject to non-competes make below $13 an hour. So that's really the focus and the lens that we are putting this through. We even heard in our conversations over the summer, certainly we don't have the exact numbers of the applicability in Vermont, but we know they apply. We know they apply to some lower paid workers. And so that's the lens in which we come. As many of you know, the Federal Trade Commission had issued a rule banning non-competes nationwide, similar to the framework that you have. And I just want to highlight something that they highlighted in their press release around the rationale for this. The FTC estimated that the final rule banning non-competes would lead to new business formation growing by 2% per year, resulting in more than 8,500 additional new businesses created each year. The final rule is expected to result in higher earnings for workers, with an estimated earnings increase for the average worker by an additional $524 per year, and is expected to lower healthcare costs by up to $194 billion over the next decade. In addition, the final rule is expected to help drive innovation, leading to an estimated increase of 17,000 to 29,000 more patents each year for the next 10 years under the final rule. Other states have certainly gone down this path. There are 34 states that have some version of NDC, that have some version of a ban or a limitation on non-competes. 3 New England states, Maine, New Hampshire, and Rhode Island, and 4 of the states would be considered total bans: California, North Dakota, Oklahoma, and Minnesota. So just a little context, this is an important issue, and we're very happy that you're working on it. Some of the specifics around provisions of S205 as Chris identified in his testimony, the income threshold is one in terms of like who this applies to or not, is one that we advocated in the work group be higher. The FTC limit was 151,000 a year approximately. And we certainly would be comfortable with that, but understand why 100,000 is a good starting point for this bill, and see if it's an effective deterrent. And that is something that I should mention, that we're really talking about for lower paid workers, deterrence here. 90% of non-competes are not negotiated. They're really take it or leave it. So for instance, if you work for a sandwich shop, this was Chris mentioned in his testimony a few weeks ago, there was a famous case of a large sandwich chain sub shop in the tri-state area that was using non-competes. Those workers, when they go to take that job or to interview for that job, they're not negotiating out non-compete clauses. They're signing what they're given. It's a take it or leave it type situation. So the broadest approach as possible is one certainly for the lower paid workers, is something we would support. In terms of these other issues around proprietary information, just want to be clear, like, this bill does not limit other ways to limit the transmittal of proprietary information. So this doesn't address non-disclosure agreements, which people could be required to sign. This doesn't address trade. I mean, there's a mention of trade secret, but clearly if somebody has a trade secret, they leave, they're not allowed to then go use that under whatever provisions of law that are currently exist. So this doesn't negate any other protections that employers may have related to protecting their proprietary information, and we think that's appropriate. One thing in review of some of the other legislation around the country, one suggestion might be, and I know employers, every time we bring this up and brought this up many times, but workplace postings, just so, there's a lot that people have to post in their workplace and a lot of information, but just so somebody that's going to apply for a job has some understanding that in fact, they are not subject to a non-compete if they're captured under for instance, the income threshold. So just some way of transmitting that information may be covered in the bill. I think there's a conversation that has to happen between workers and prospective employees and employers, but potential, it's just popped up in other bills, workplace postings related to non-competes as a requirement. The DOL is good at creating these and they're pretty simple to do. So another issue, and for the vast majority of workers, even if this bill goes into effect, which we think is a really good thing, we see this as a sort of a barrier to prophylactic ability to prevent employers from doing this, but for most people, working people, their ability to actually bring a claim is very difficult. To go out and hire a lawyer to bring a claim for a violation of even this statute. And I should say, we support the remedy provisions in this bill. I think it's under 495B, and that's good. That's a great starting point. Some other states have considered in legislation a liquidated damages clause. So for instance, if we had a clause in there that set a defined amount of a violation, which said if you violate this law, you're subject to, I'll just throw this number out, a $10,000 penalty per violation, and all the other remedies that are contained under 495B. That sends a message to employers, follow the law. It's the law. Because oftentimes for individuals who are subject to a violation of the law, it's just the barrier to entry for the legal system is really high for folks. So it'd be difficult to, that's a suggestion that you may want to include or at least discuss. And then we had a discussion in our work group about sort of whether this would apply to current existing contracts or not. And sort of, I'm not an expert on contract clause and all of that. There was some legal question about whether it could apply to it. The FTC rule did apply to existing non-competes. And so as I read this, I don't see anything in it that says it shouldn't or wouldn't apply to existing non-compete clauses. But that's a legal question. If retroactivity is legally possible, we would certainly support that, particularly for those workers that are under the threshold. Just doesn't make sense to have a workplace that has, the 5 new employees at the sandwich shop that aren't subject to non-competes and the 5 existing employees at the sandwich shop that are. So that's really a legal question more, but philosophically, and the FTC obviously felt it was appropriate. Now, I should say the FTC rule was, there was a court case brought against the FTC rule. The rule was stayed and pending further appellate review. And then ultimately the Trump administration decided to not pursue that. So I don't know if that question has been, that Sophie may know whether that question about applicability has been resolved or not. So those are my main issues. I'm happy to come back and talk about as you're moving through the specific provisions of the bill. But I think you've done, this is a really great start and on a very important issue for working Vermonters.
I'm just curious, this bill only covers non-exempt employees. Are you seeing salaried employees in the $50,000 to $100,000 range, or at what point do you start to see more exempt employees versus non-exempt employees income wise?
I mean, I've had a few of these cases and they've been, the cases when I was practicing were more the higher wage workers. We do know, and we heard in some of the discussions that we had, that the lower wage workers are subject to these non-competes. And we certainly know that to be the case in other places. So for instance, now we're starting to see, I live in Burlington, and in Burlington and outside in Williston, we see, every time there's a new chain that comes into Williston, it's celebrated by my kids, the crumble cookies and the sub shops and all of that. Now, I'm not saying any of them do this, but we know from the experience in other states that those types of chain stores have in the past subject their employees to this. So this is really like a protective measure to prevent that from happening.
But
So,
most of these companies, Cookie Crumble and all, they're paying by the hour.
yeah. And I mean, my reading of this is they would be protected by.
Correct.
Yeah.
Yeah, I was just trying to figure out the threshold because
Yeah.
as many people had mentioned here, the $100,000, I have an issue with it. Not so much the number, not so much that it's there, but is that the right number?
Yeah.
And also the ambiguity around, the positions.
Yeah.
And I'm trying to kind of maybe pick up some solutions to hone that down and make it a little more
Yeah.
unambiguous.
I think because it's an 100,000 and an executive, I think certainly the definition of who is an executive could be clarified, as Chris and others have mentioned. I think that could use some further honing in on who exactly would be considered an executive. So.
Can you talk a little bit more about the notice for employees that you mentioned? That's for stay or pay?
Yeah, the stay or pay provision. Yeah, that's not something that I've focused on. I'm happy to think about it, certainly.
But you did mention it, right? I didn't.
Postings for non.
Oh, okay.
Yeah, I was talking about the postings. Yeah. So just to clarify for those that aren't familiar, I don't see one here, but in every workplace, there's a requirement that, for instance, your right to workers' comp or OSHA requirements, and the posters get small print and get bigger and bigger as we go. But for some people, that could be I just think people knowing about their rights, and most employees that are going to go for a job aren't thinking like, we're going to have to negotiate a non-compete agreement, or that they wouldn't, even if one was included, they wouldn't know that they were prohibited in the state of Vermont. So just some level of knowledge. And I think there is provision in the bill that talks about, give it to people that have a period to think about it. So, but just as a general rule, having more information is better. So, yeah.
Questions? Great. Thank you, David.
Great. Thanks so much.
Austin?
Good morning, all.
Great. Well,
You folks had a better slushy drive in than I had. For the record, Austin Davis, I'm the Director of Government Affairs of the Lake Champlain Chamber. I have testified on this issue many times over the years. And so I'd like to just thank you folks for the diligent work you've done to grapple with this area of policy that's very intentionally difficult, because it's dealing with these gray areas between different protections and trying to balance employee flexibility with employer protections of intellectual property, as well as the more difficult things to describe in this, just even like the ethical considerations that follow along these. So I thank you for working for that nuance. I want to thank Chris for his work on the working group over the summer. We participated in that, as well as Jessa and David for participating in that as well. I think we believe that these agreements have important uses to protect, from outcomes spanning from impropriety to illegal actions to just downright unethical things. And we've heard some outlandish examples that were kind of framed and happening at the national level and chains and such like that. However, we haven't really seen much evidence of these being misused in Vermont. And it seems that our judicial system is working as designed on our reasonableness standard to handle these as a case-by-case basis. We agree that, in many of those outlandish and outrageous examples, they need to be restrained. And we want to keep working towards a solution that can accommodate restricting the use of those in just in instances that we can all agree that they're not supposed to be, while protecting them for very important aspects of our economy, our small businesses, our startups, our tech sector, et cetera. My colleague who just departed from working for our business accelerator, would remind me that these are an instrument that employers don't take lightly, that they weigh their options when including these in the employment contracts. And that's because sometimes it has an effect of narrowing the talent pool that you're putting the job out for. Some folks will not want to enter into a contract for employment with a non-compete agreement. They won't want to limit their options. Others will look at, do the broader calculation and say, this is the place I want to be. This is the opportunity I want to go for. I'm fine with the non-compete agreement. I know how to work with that. And they will make that decision or they'll likely negotiate based off that. So I just want to reiterate that, in our competitive labor market, where it's difficult to hire talented people, employees, including non-competes is not taken lightly. They understand that what they're doing in terms of narrowing the potential field of applicants in there. We see this in the startup sector in less voluntary instances too. Not long ago, I think a couple of legislators in this room, as well as some of the advocates in this room, we were at a talk a few years ago maybe, with our state treasurer and other businesses about accessing capital. And one thing that actually one of a very notable aerospace startup mentioned was how when they started accessing capital to grow themselves as a Vermont employer, many of those financiers wanted to see non-compete agreements because when they're at the ground floor of this innovation, the risk is very high for one individual to just kind of take what they have and immediately act on it. These are valuable. An employee can't necessarily unlearn a business strategy. An NDA, allows for the business to sue after the damages and the secret's out. But for a startup, once a competitor knows your roadmap, they can grab that first mover advantage and move with it very fast, and it's gone forever. And so we have a lot of scrappy startups here in Vermont who are competing against the behemoths at the national level and international level. And they're doing so to great effect. This is one of the few tools that they have in their arsenal to go against these Goliaths. If you have someone from a 5-person small Vermont business move to a direct competitor, they don't have to steal anything. They already know what experiments failed, what marketing channels didn't work, where money was wasted, and they can just kind of move forward with that knowledge and also knowledge of what the company they're leaving was going to do for the next 6 months. So I think in the context of small Vermont startups, the current salary threshold, as Chris alluded to, and executive standard proposal here are quite difficult. I think of many founders of startups aren't necessarily taking a salary at this level even. And many of the folks who are in the early stage are doing so to be on the ground floor and to be there for the innovation, not necessarily for the wages. There's a total compensation package that, might exceed that. Let's say if there's sweat equity involved, or just an intangible compensation in terms of just the experience of being at the cutting edge of this field, this technology, this industry that folks might be putting into their calculation when they're deciding to work with an employer. One thing I would say is maybe have section 2, subsection 8(1) reflect, not just this, instead of having the language of salary threshold and executive status, make that an or. and then work on what that executive status truly means in terms of proprietary information, and, access to key components of the business. This might be worth looking at the size of companies. I think there's an you zoom out, there's an interesting contrast when we're talking about a compete agreement in the contrast of a very large multinational corporation where things are very much siloed. And they are, you're working in a specific division, you don't have much information about what's happening in others. And a Vermont employer, or a small business, and when I say small business, I can be speaking to businesses up to 100+ employees, but small businesses where many employees operate as a generalist in a way that they want in a large, and they have a lot of cross-cutting knowledge of what other teams are doing, that exceeds what you would at the same job title in a much larger corporation. You know what research and development, the marketing, what all these other departments are doing just by virtue of, how the lunchroom works and just the size and having to wear many hats. So, I think we'd like to see potentially that dual test be multiple single tests, that are tailored to those specific issues. An executive employee at the highest level, might have critical knowledge too, but, a senior employee who's, mid-level could have been they're longer than the CEO and have just as much knowledge. In terms of solicitation, I echo, some of the comments of Chris around guardrails here. The millennial in me sees this kind of as a slightly dated issue. When I like someone who's rendered me a service and they move on, if the person at the front desk says they're not here anymore, and I say, where are they? And they say, I don't know. I pull out my phone and I quickly Google their name, and I can generally find where they've set up shop elsewhere. So, customers will follow talent that they appreciate, I think, in this day and age. And it's easier than ever to do that. That said, I understand what this provision is trying to get at, and I certainly don't want a situation, and this is already handled in case law when talking to some of the attorneys in my membership. I don't want a situation where somebody walks into a provider's office by their choice after they've Googled that provider, and say, hey, I found you after you left my old provider. I like you and I want to be a patient or a client. We don't want a situation in which just the fact that they render that service and that instance, once the person's found them, they might be seen as violating non-solicitation. So I understand that context. That's a slightly more weedy area, a little bit more gray. It's something that frankly, our judicial system was better suited to understand, but I understand what you're getting at here. I appreciate the direction. I agree with Chris that maybe some more conversation might need to happen around just guardrails for, fiduciaries, providers, attorneys, et cetera. And then that brings me to stay or pay. And I think this is an important conversation around, companies investing time and money to their employees. And just thinking about this in the context of potential reluctance of employers to do that, as there's constraints on it. We talk to many employers in this tight labor market who will start employees at high wages, just with the understanding that they will be training them up at a 6-month interval and then raising their wages even more. And we want that. I think in this really difficult environment that we have, labor market that we have, due to all the things we talked about ad nauseum, our demographic crisis, and so much more, we want employers to take that initiative and find people and invest in them. The question then becomes, once they invest in them, what stops another person from coming in and kind of seizing that investment? And to the employee, they're not looking at the broader balance sheet of how the employers decided to make this work. The employees are saying, I can get a little bit more if I go to this next employer, and thanks for the training. So these are important. And I think that there's some really reasonable, the 5 criteria that are in here are really reasonable, but I want to just kind of specifically zoom in on, the transferability of high value certifications and the like, and the proration of that debt. And I think, we have to think about this in the context of like the economic principles of your sunk cost and your realized value gap, right? And to make this most down to home, I think about this in the context of like a home renovation. If you have a contractor that you want to come in and say, completely renovate a kitchen or bathroom, expensive project, and, they strip the kitchen down to the studs, and then they decide, you know what, this job isn't for me, I can make more money down the road, and they leave, they're 20% done, but you're in a situation where you're left in a worse off place. You've made the initial investment. Just saying, well, you owe 20% and that's a deal isn't actually, it's kind of adding insult to injury to some extent. So if you think about this in the context of a business who say pays for like a 3 months intensive certificate for an employee, and then that employee decides to leave, before the state of pay agreement is done, the company is paid, 100% of the cost of that, and they've recouped 0% of the value of that. And so, the prorated conversation doesn't really work there in that situation. They haven't really gotten the value of that certificate at that time. So, in short, these are just not linear. These are kind of agreements. And I just think that some clarity around that would be helpful in the statute to make sure that, employers can recoup in an effective way, the actual cost of these services. And then, I think in closing, I just, again, thank you all for this work. I think these are important agreements, and I'd be remiss to not point out, which I have before, that, as legislators, you have a de facto non-compete agreement that prevents you from, very specifically lobbying within the state of Vermont for 1 year at the conclusion of your term, right? And, previous legislatures have had the foresight to believe that a cooling off period is important to protect the state of Vermont from improper or unethical use of what was made available to you by virtue of trust of your constituents and that put members in the General Assembly. Both non-competes and the agreement you have are about protecting the integrity of a specialized relationship and inside information gained through positions of trust. So we remain committed to working with you on this as we have over the years. We thank you for the work you've done so far and building a much more palatable version of this. And would love to come back if need be to have discussions around as you folks discuss the things that were brought up here today.
For Austin?
You want to go first? I just have one little pushback. We've had this situation in our family where you have an appointment with a medical provider and you made it 8 months ago, and you get the call, to confirm your insurance a couple of days before, and they tell you that person, your appointment is with someone else, and you say, why is my appointment with someone else? And they tell you that person isn't there anymore. And then you have to so you've been waiting, right, months. And then if you track this person down, you're waiting another 8, 10. For us, it's been really long to get services. And so that's where I feel like that Google the person analogy doesn't quite fit.
Mm-hmm.
And so I appreciate we can track people down better than we ever have been able to. And also the harm that can be done to the consumer by not having that information in a more timely way is real. And so, especially in the medical world, also, in these other situations, maybe not as much harm, but it's still an issue. So I, again, appreciate that we can find people, and also I think there's more there.
Yeah, and I should have been more clear. I mean, I think that the notification is fine. I understand that. I think it does insert more gray area. But I think some guardrails can tighten up standard form language for notification, some criteria around what that looks like. Because there's a big difference between like like something that crosses the line into the solicitation is an advertisement, and something that is just a notification that says, I moved on, here's my contact information. Those are very different. So if we could put some more there, that'd be helpful.
Purpose first.
So I appreciate the testimony and, you know, there are a lot of points, as other witnesses mentioned about need for some clarification around terms and things like that. I think that's very, very helpful. One of the issues that you mentioned was how you define an executive employee or some other employee that has proprietary information. And I'm wondering, I'd love for you to think about, you know, specifically how to further define that, to clarify it. It seems to me that there are different types of proprietary information. Some of them have very concrete, you know, it's a concrete thing that maybe you can deal with in a non-disclosure agreement, and others, like you say, you know, maybe it's strategy, some stuff that it's harder to pinpoint. So would you be able to think about, you know, how to specifically how to address that issue in the definition? I think it would be helpful.
Yeah, so I think that it's an interesting conversation around just how the gates work. You know, in my testimony, I said that, so thank you for asking this follow-up. You know, there's a wage threshold you folks want. I'd say that the wage threshold as written is too high. You know, I think of that said, you know, I think we can all agree that folks working in sandwich shops are not necessarily, should not be covered by these agreements. So, you know, what if we had a conversation about having, you know, stage gates that folks go through and starting with a very low wage threshold or a lower wage threshold, such that we are sure that we're not pulling in sandwich shop workers, but then start defining what these important criteria that folks are working on. And this is where it gets kind of difficult. I mean, like I said, I've been discussing this with the legislature since, you know, pre-2020, I think. And I remember back in 2019, having an employer in here talking about how for them, collaboration is just such a competitive advantage. And this is an employer who's doing incredible things at a global scale with optics, like, you know, printing and photography, et cetera. And, you know, his thing is, anyone who's in my business, I'd like to, you know, create an environment where they can advance, where they can learn, where they can be part of the team. And he's like, the difficulty is, you know, I want to invest in these people and trust them with this, and not have them go to Samsung or some other, you know, or some other international competitor. So, you know, it becomes a question of like, how do you filter in? You don't want to suppress, let's say, like the sharing and collaboration that happens. That's really important to building the ecosystem we want, the innovative ecosystem we want. We also want to balance these protections. I think that starting with a lower salary threshold than what's proposed and then building on proprietary information from there is a valuable way to go. I also think, again, looking at the size of the employer is valuable as well. You know, there's a difference between your large multinationals that have silos, and then your small Vermont employers who, you know, your mid-level employees can have just as much information, if not more at times, than some of the executive employees. So I'd love to chat. I think that's a much bigger conversation, but you know, I think Representative Mix, you were getting at it a little bit too, the exempt, non-exempt. But I think broadly what you're hearing from us is that there's a lot of gray areas and nuance in it. And it's kind of by design. Like I said, these are covering the gray areas between trade secrets and non-disclosures and other components of our laws, because it's protecting some of that, you know, scrappiness that happens at small scale, the first mover advantage, competing on an international scale with large, you know, companies, et cetera. I don't know if that was sufficient.
No, no.
I'm sorry.
Can I have one more follow-up or you? I can wait.
Abby has a question, then we have Sarah, and then.
I just want to understand better your testimony about the proration stay or pay. Like, I didn't fully understand the concern about the language in here now. Like, because right now it's sort of, the agreement would the amount that what the employee would have to repay would decrease over time based on the agreement. But it doesn't specify how quickly it would go down, right? So.
Yeah, I think more just some meat on the bones there to understand, because I would hate to see a situation where someone disagrees with their proration and then challenges it. I think,
So you just want more specifics about how that would
and I
work?
don't think it's necessarily like we could assign different value schemes to the proration. Like you might think it's just a linear proration. I might think it's more of an exponential. If we have an agreement that means that you need to stay in employment for 1 year after I invest in your training, to you might say, well, I'm 6 months into that agreement. You've gotten 50% of the value. To me, I might be like, no, I haven't gotten. Actually, really, like I've gotten 20% of the value. Over the next 4 months, I'd say I get 40% more of the value. And then really the last 3 months of this project that I trained you for are where the bulk of the value comes from of that training, So I think just reflecting that and just understanding that these agreements, it's not as clear cut. Employers work on different timetables all the time. Like I might have sent you to a training out of state to work on a very specific job that we're working on. Let's say it's like, something advanced, like horizontal directional drilling through foundations or something like that. And that is like not a really important part until the end of the job, but you're leaving before the end of the job. I've gotten 0% of the value in that training, Thank you.
Sarah? Morning. Thank you for joining us this morning.
Thank you. Thanks for having me.
So if you could just state your name for the record and then continue on with your testimony.
Great. Yeah. My name is Sarah Crandall, and I'm here to share my story about experience with the non-compete agreement. I live in Hardwick, Vermont, and I moved to Vermont in 2021 as a chiropractor. I had just graduated chiropractic school, and I took a job in East Hardwick, and the non-compete agreement there was a 30-mile radius for 2 years. And essentially, I was hired, in my opinion, into a practice that actually didn't have enough clientele to support a third chiropractor. So, I was never actually able to get up to much of a good wage at all due to that. And yeah, sorry, I got I got a little nervous. I've never testified before.
Not a problem.
Yeah. And so I left that job. I had a 3-year contract there. I left that job in August of 2024. So in August of this year, 26, my non-compete will be up. And I did have a lot of people telling me, a lot of other chiropractors saying, non-competes can't really hold up. And I did contact a lawyer. The issue with with contacting a lawyer is I contacted at least 17 lawyers to try to find someone that would work with me. So it was extremely hard to find a lawyer in the first place had I wanted to, fight this non-compete. And asking them like literally like 5 questions with follow-ups was over $2,000. And so that felt really prohibitive to even fight the non-compete that I felt was pretty extremely broad. 30 miles is really far from this community and is outside of every major town. You know, it's outside of Stowe, it's outside of Montpelier, outside of St. Johnsbury. There's Newport that would be available, and otherwise, you know, you're traveling an hour basically from your community. So yeah, that is the real basics of it. And I feel like, you know, looking back, it's easy to see that I was in a really vulnerable position, having just graduated chiropractic school and not being experienced at all, and, you know, entering into a bad contract. And yeah, the other thing, I'm not sure how, you know, how important it is, but it was, the wages there were pretty much under 25,000, and, you know, the highest that it ever got under 30. It was not to have to be 30 miles away, traveling basically an hour from your community, and not having had enough money to even live on for this last 3 years makes it pretty much impossible, in my opinion, to go start a brand new practice from the ground up, you know, 30 miles away. And there aren't really a lot of other chiropractors in the Northeast Kingdom. There's a handful, and so there's not a lot of competition already. And so there's a lot of people that need care here that just aren't getting it, aren't able to get it without traveling pretty far. And for whatever it's worth, you know, during this non-compete time, since I've been away from that business, the business I left has pretty much been closed down a lot of time, from what I hear, due to the illness of the owner. So that business is not very available either. So I think that's the gist of it. I'm happy to answer any questions.
Okay, thank you.
Yeah.
Tony?
Hi, Sarah. Tony
Hi.
Nicholas. I'm just curious about the terms of your agreement with the chiropractor. Were they paying you by the hour? Were they paying you by the job? Was it a contract? Was it salary?
Yeah, so it's a little bit complicated. I got a base pay of 25,000, and then anything, like I had to earn 6,000. Anything over that, I earned a percentage of, 30% of. And that would be like, it would take a couple of months to get paid because we took insurance. So after the insurance was calculated, you know, we were a couple months behind on, if that makes sense. So whatever I earned in January, I'd actually get paid for in March.
So you basically got a base pay and then, like, I guess for lack of a better word, a commission on top of that.
Yeah.
Okay, thank you.
Yeah.
Questions? So your employment contract was for 3 years?
3 years, yes.
Okay, and then did you decide to not sign a new contract, or did the employer decide that you know, he didn't want you, he wasn't going to employ you any longer?
Yeah, that was my choice to leave. Before I had to give a 90-day notice, so I put my notice in May. My contract would have renewed. Notice in before my contract renewed, yeah.
Can you say that over again, because we lost you for a minute?
Oh, sorry, am I here?
Yeah.
You're good now.
Yes, I put my notice in May, and my contract would have run out in July.
Okay.
And I had to give a 90-day notice, so I actually left, you know, in August.
And then you can't practice now for 2 years.
Correct. So this August will be the end of the second year. I could
Yeah.
start in August.
Yeah. I think it'd be pretty hard for them to stop you from earning a living. Courts have pretty much Okay,
I'm so sorry. Now I lost you. I think it would be pretty hard, and then I didn't hear after that.
yeah, it may be hard for them to win in court when they're stopping you from earning a living, but we don't know. That's the reason why we're looking at this.
Yeah. Yeah, it's definitely been challenging. I can see both sides of the argument in many ways, and having experienced it, and I feel very grateful. I've had other things to fall back on where I've been able to have employment, but if I would have if that was the only thing I had and had to, that would have been impossible, I think. It would take, in my estimation, at least a year to try to build up to a decent practice size that could keep you sustained. I mean, I'm sure that all has a lot of variables, but that's sort of what was on my mind about it.
Did you have patients that were trying to try to get in touch with you? For you
I've had
to-
a few reach out and they're like, "Where are you?" And it's it's really awkward, And they're like, "The office is closed down. I would like to get care." And yeah, it's really hard.
John?
Good morning, Sarah.
Yeah, sorry.
Good morning, Sarah. I'm Jonathan Cooper. I'm a representative from the southwestern corner of the state. And thank you for joining us today. And my question for you is whether that non-compete, in your knowledge of the industry, or just specifically in your instance, was that non-compete a negotiable element, or was that a take it or leave it circumstance? And as far as you know, and any other, is that something that is common among the people that you went to chiropractic school with in their experiences?
Yeah, that's a really good question. I had no understanding that that could be negotiable at the time. And so I don't think so. This owner was pretty firm on the contract, and other folks that I've talked to from other states, um, there's I remember in Atlanta that someone had to sign a 7-mile agreement, and that felt egregious there because 7 miles puts you, almost outside the city. Um, but I think from what I understand, they're pretty firm. It's sort of a take it or leave it.
Okay, thank you.
Yeah.
Good morning, Sarah. Good to see you, Kirk White from Bethel. And so when you said so you couldn't solicit any of your previous clients, but some of them found you. Did you feel like you were able to provide chiropractic services to them, or because of that, the fear of that non-compete, you had to turn them away from that and offer something else or refer them or whatever?
Yeah. No, I still maintain my chiropractic license, but my business is now, doing energy work, which is the other thing that I was already doing. And so my business is not a chiropractic business. I'm not insured as a chiropractor. Um, there was a lot of fear. I was threatened with, like, these are literally the 5 ways I will sue you if you break this contract. And I took that really seriously. And like I said, it was really hard to find a lawyer and really expensive. So I was like, even if there was a chance of like winning, I don't think I could have afforded the cost. Um, yeah.
Any other questions for Sarah? Edie?
I guess, thank you, Sarah. Edie Granning from Jericho. You bring up an interesting point, which is that you have a license to maintain and you can't see clients in a region. And so you actually have a cost associated, possibly, right? Depending on when this happens.
A lot of cost, yeah.
Yeah, I think that's just an important piece for us to know here.
Yeah, I would say, the license renews every 2 years. It's about $300, and it costs, I would estimate, about $1,000 every 2 years to take the appropriate amount of continuing education. So, $1,300 every couple of years to maintain. Yeah.
Thank you.
Yeah.
people under bracket.
Right, without the ability to
Yeah.
work in the field.
Yeah.
Any other questions for Sarah? Sarah, thank you. We appreciate your testimony and certainly helpful to us and we're hoping we'll be able to do something so others don't get caught up in the same issues that you're caught up in.
Thank you very much. Yeah, I really appreciate what you guys are doing. And can I ask one question
Sure.
about the bill? Just something that came to mind in the non-solicitation part was there was a line that said that you couldn't transact business with former clients or customers. And I was curious how that might relate to let's say I didn't have a non-compete, but I had a non-solicitation. If I were to advertise in the area, I was told that that could be viewed as soliciting to clients because those clients already were in that area. That's just a thought that was on my mind. Thought I would pass that along.
I can, this is Abby Duke from Burlington. The transact is not in the bill anymore in the latest draft, so it is, so it doesn't, so the non-solicitation does not include transact. You see what I mean? So that was why we put in that, in the current draft, if you were to leave, you could notify patients, I have left, this is where I am now. And you could also do transactions. You just couldn't solicit those former clients.
Okay, great.
Would advertising be solicitation? I don't think so. Because it's not. I mean, that's my understanding.
And I'm a real estate broker, so I totally understand what you're talking about a license and all that stuff. I will share with you what the policy is in real estate. We have to take code of ethics and things like that. In real estate, if you move to another agency, you are not allowed to solicit these specific customers. However, if they of their own free will say, I want to work with you, and they choose to terminate their contract with the previous brokerage, that is totally within the purview. We've also been instructed that if you're going to do like a blanket mass mailing to a specific area, that is not considered soliciting, as opposed to taking your names list and sending a personalized letter. That would be. That is the way it works in real estate. If that helps.
Yeah, that does help. Thank you. Yeah.
Anything else for Sarah? Great. Thank you, Sarah.
Thank you so much. Good luck.
Thanks. So we've heard some suggestions that Abby and Herbie can work with Sophie on. I think there's some things that we could do. Instead of, I'm thinking, this is what I'm thinking, I don't know what the committee is thinking, but straight $100,000, I think we look at it. X amount above poverty level. And I like the idea of creating, you either use that or you use a definition where you're, could be a mid-level, but if you have, if you're counted on and you're salaried and you're counted on to do specific things, and they could be proprietary information, that sort of thing, so either a wage threshold or this, and then of course looking at the executive and trying to figure that out. I think there were other good suggestions as well. But Michael.
I hate to be the stick in the mud, but I am gonna be. I mean, I'm perfectly fine with banning no competes for non-exempt employees. I'm not on board with messing with no competes for exempt employees. I feel bad what happened to Sarah. And the thing that I was thinking about is the business there who doesn't have a lot of people to pull from in Hardwick. And if there was a situation where, you know, that could actually cause a business that's currently in existence to fail, right? So, and I think I'm just gonna just say a hard line, like, you know, if we want to ban them for non-exempt employees, I'm fine with that, but to start meddling in the exempt employees, I'm really not comfortable with. But I'm just one person, so. I know, I'm a terrible stick in the mud and evil person. It's okay. I mean, it's not the first time I've been called evil already
I
today.
guess my question for you is, we're trying to draw the line at an incredibly high level employee. And a non-exempt employee isn't only, that is not, there are a lot of people who are non-exempt employees who are not top of the business employees, right? Most businesses, you know, so I think that's, I think it's almost an arbitrary place to draw the line when you're saying exempt versus non-exempt. And so, because it doesn't take into account the job, the knowledge, and all of those things, which is what this bill is trying to do. And so, I just want to, you know, I would want to talk more about what an exempt employee is and what, you know, it's somebody who manages other people, right? You're exempt if you have employees, right? Like that's one of the things. If you have a bachelor's degree, that's one of the things. So the things that put you into that category might not be the things that mean that you can start a new business and earn a big wage and, you know, do all of those things. And that's my pushback on it.
No, and I get that. I mean, the exempt versus non-exempt is, to my understanding, is pretty clear in the labor law from like 1930s, I think it's, and it's, you can't just be an exempt employee for work that you do. It's like there's specialization involved where it kicks it up to the non-exempt position. And that's the reason why I just think that's a bar to set for me. And again, it's just me. And like I said, it's not the first time already today that I've been called evil. So
I want to explain my thought process and why I actually think the two-part test is important. So, I mean, number one, I think we're all in agreement that lower wage hourly employees, clearly there should not be non-compete agreements, right? But so then we're talking about this other class of employees. And you start thinking about different scenarios in which there could be a non-compete agreement. And I think that's why the reason for a two-part test is, number one, they're making a wage in which they can actually pay their bills. That is not, I think, and then I'll get into that a little bit more. And then number two, also, they are an important, critical employee to the organization. And I get Austin's testimony about very small employers who might have 5 employees, and each one of those knows everything about the business, right? So then when you think about those 5 employees, we tend to romanticize startups. We tend to romanticize, like, so somebody's making $25,000 and they're working 80 hours a week and they can't pay their mortgage, they can't pay their rent. And it seemed like a good idea. The startup is not taking off, right? There is not a vision in which in the near future, they will be able to pay their bills, even though they're a critical employee. Then I don't think they should be held to a non-compete because they're going to go, because they're going to go to a competitor. However, if they're making, and so I think that's where we think about what is that level, and the percent of poverty line, for example, could be it. Let's say that person's making $105,000, then that is, and they're a critical employee, well, okay, then maybe a non-compete is appropriate. So we can't not, I don't think we can not have a floor of what that salary is. And then I think then the definition of what is a critical employee is, where we knew when we were working, we knew that we were sort of, let's put one out there, which is that senior executive at the highest level. Whereas I think that definition, I think, does need work in order to capture the intent, which is really those critical employees. So does that make sense about those ideas of those two, of why I think that two-part test is important? Or if it's not a two-part test, then that salary floor would need to be higher. So that, but I don't know if somebody's making $200,000 a year and they're not a critical employee, should they be held to a non-compete? And then to keep going on points, I think we're talking about medical care providers, I actually think is different. And I think Sarah's case shows several of those elements. Number one, she was not making enough money to pay her bills and was being held to a non-compete agreement. I don't think that's right or should be allowed. And then I think the medical, and in medical providers, I think are a little bit of a different case than whether. So anyway, those are some thoughts.
Yeah.
So, committee were at National Life in half an hour. We're back here at 1:30 to take a look at 211, and that is Bill has the testimony. And then we'll have the floor. No, then more is coming in at 3 on the floor at 3:30. So with that, we can go offline.